difficulties, a chat box will be located in the pharmaceutical waste, the latest from the DEA and the EPA. Today's date is March 26, 2019. Opioids and other controlled substances are getting a lot of attention, as are all pharmaceuticals, for their misuse, their persistence in waterways, their environmental impacts, and the high cost of proper management. Charlotte Smith of Pharmacology Waste Management joins us today to walk us through Practice Green Health's newest resource, which is a guidance document on best practices for disposal of controlled substances. And she'll be providing an overview of the new hazardous waste pharmaceutical rules as they apply to controlled and hazardous pharmaceuticals. The guidance document is a membership benefit available for download on the pharmaceutical page of the waste section of the website. This webinar is solely for educational purposes and provides only a general description of various regulatory requirements. For a complete description, please consult the relevant federal and state regulatory statutes. Nothing in this presentation constitutes legal advice, and you should not legally rely on any information provided in this presentation. We make no warranty, express or implied, with respect to such information and disclaim all liability resulting from any use or reliance of this information. Janet Howard, Director of our Member Engagement Team at Practice Green Health, coordinated the development of the guidance document entitled Best Practices for Disposal of Controlled Substances. And she coordinated with key stakeholders in the healthcare sector community, and we would like to acknowledge them for their expertise and time given toward this effort. They include Charlotte Smith, Senior Regulatory Advisor for Pharmacology Waste Management Sustainability Services, Bob Spurgeon, President of Spurgeon and Associates, Matthew Hurray, Kaiser Permanente Senior Principal Consultant. We thank them for their contribution to this new resource. Our learning objectives today are to review the steps of Practice Green Health's guidance document and to help healthcare facilities and providers through the legal management of controlled and hazardous substances that are no longer needed. Understand the change in the DEA and the EPA regulatory status, controlled substances that are in inventory versus dispensed. And then learn about the EPA's new hazardous waste pharmaceuticals rule and when it will impact controlled substance wastage and returns in our hospitals. Our presenter today is Charlotte Smith, Senior Regulatory Advisor for Waste Management and Pharmacology. Charlotte founded Pharmacology Associates, LLC, in 2000 and sold the company to Waste Management in 2009, where she now works as the Senior Regulatory Advisor. She also co-founded Capital Returns in 1991, a nationally known pharmaceutical reverse distributor, and for 10 years has served as the President and Chief Regulatory Advisor. Charlotte is a registered pharmacist and a member of the Pharmacy Society of Wisconsin and the American Society of Health System Pharmacists. She has been a friend of Practice Green Health since our early H2E days, and we are grateful for her knowledge, expertise, and passion that she shares with our community. So, Charlotte, thank you. And with that, I'd like to pass it over to you and take us through today's presentation.
Thank you, Julie. Hopefully you can hear me okay.
I can.
Wonderful. I have been participating in the Great American Flu Season, so I apologize for being a little bit hoarse, but hopefully it won't get into the way in the way of our conversation today. So we want to thank everybody for joining us. We have so many different intersecting regulations that folks in healthcare need to worry about. So hopefully this will help clarify at least part of this. And we want to talk a little bit about the rationale for developing these best practices, and this document is years in the making, so to speak. So as you're all aware, we've got an increased concern over pharmaceuticals in the waterways, and we have a number of states that do have no drugs down the drain rules, but that's not nationwide. We also are very concerned about the potential diversion risks. Everybody's heard about the opioid crisis. So we're worried about our employees, patients, and visitors within healthcare. And we want to talk today about the DEA's drug disposal regulations, which are not new. They're authorized by the Secure and Responsible Drug Disposal Act of 2010. So that's 9 years ago already. And for those of you who have been in this for a long time, you recall that until then, we really didn't have a way for an ultimate user to return a controlled substance that was no longer needed, other than to give it to law enforcement, which wasn't that attractive. So DEA took that opportunity as they proposed their regs in 2014 or finalized them in 2014. They took that opportunity to also include additional conditions regarding the management of controlled substances in both inventory and wastage. And those are two terms that we're really going to stress today. We also want to be sure that as you're working through this, you're complying with EPA's hazardous waste regulations. And as you've mentioned, Julie, those will be changing in the near future and kind of in a rolling cadence over the next couple of years. So I want to mention that the guidance document was finalized prior to the publication of EPA's final rule, and therefore that was not taken into consideration as we did that guidance document. So at some point we may want to take another look at that. I'd like to back up a little bit, though, for those of you that may not be as familiar with the Controlled Substances Act. This was enacted in 1970, and it's enforced by the Drug Enforcement Administration, or DEA, which is part of the Department of Justice. And, of course, it restricts access to controlled substances to those who are registered, and that's the key word, to manufacture, distribute, prescribe, or dispense these products. All regulated substances are placed into one of 5 schedules. I've been around long enough, I remember the old rule, which was only on narcotic control. We had A, B, and X narcotics, and those were only the opioids. And then people got pretty creative in the 60s and found a lot more substances to abuse, and that's really what stimulated the Controlled Substances Act. So if we take a look at the schedules, just to level set ourselves there, Schedule 1 drugs have no recognized medical use and a high abuse potential. And marijuana, of course, is one of those that's now in transition, but it is still a Schedule 1 drug federally. Also, we've got heroin in there, LSD, methaqualone, used to be a prescription drug, no longer, peyote, and a whole number of substances in this particular schedule that most of us really never deal with. Schedule 2 drugs are really the ones we think about when we think about the opioid crisis. We've got hydrocodone in there, hydromorphone, fentanyl, the really heavy hitters. We've also got the very powerful stimulants such as dextroamphetamine, methamphetamine, methylphenidate, or Ritalin. So these are the drugs that the most of attention is focused on, and we'll talk a little bit more about that as we move through this. Then we've got Schedule 3 drugs, which are moderate to low potential, Tylenol with codeine being probably the most common. But you also see the anabolic steroids in there, including testosterone. People kind of raise their eyebrows, why testosterone? Well, that's from doping, bodybuilders using anabolic steroids to increase their strength and performance. So as soon as a drug becomes abused, it's eligible, so to speak, to be included into one of the schedules. Schedule 4 drugs are the common tranquilizers like Xanax, Valium, Ativan, Talwin. And then Schedule 5 drugs have a lower abuse potential, the lowest, and that's mostly your Robitussin or other codeine cough syrups and the low modal use for diarrhea. So that at least gives you an idea of what the schedules are and how they're looked at from DEA's perspective. So the DEA disposal regulation is actually almost 5 years old now. It was published in September of 2014. It took effect in October, and it has requirements to govern the secure disposal of controlled substances by both DEA registrants and ultimate users. One of the wonderful things it did, it expanded options for take-back events, and it created the whole mail-back and collection receptacle options. And DEA was quite optimistic when they first came out with this. If you recall, they stopped doing their biannual take-back days because they figured the industry would suddenly move into this. Well, it took a lot longer than expected. So they've reinstituted the take-back days. Plus, as we know now, many of you can go to some of your local chains or independent stores and have a kiosk available, which is great. A number of our law enforcement offices have these provided funded one way or another. So we've got a lot more options now in these last 5 years for getting rid of those home-generated controlled substances. So the other things that the drug disposal reg did, it did give a lot of options for a number of registrants, including manufacturers, distributors, reverse distributors, and so on, to participate in these events. I think what we've really seen realistically, though, is primarily retail pharmacies and then some hospitals and clinics that have decided to voluntarily participate in take-back options, such as mailbacks or kiosks. And then pharmacies are also authorized to maintain collection receptacles at long-term care facilities. It's not mandated. It costs money, of course, and there's been apparently some difficulties with some of the state boards requiring pharmacy employees to be there when those are changed out, and apparently that has slowed down that opportunity, but it certainly does exist. The other thing they took the opportunity to do at DEA was to reorganize and consolidate some of the regulations on disposal and the role of reverse distributors. So we're going to be focusing primarily today on registrant disposal. So that would include hospitals, clinics, physicians, veterinarians, dentists, anybody who holds a DEA registration, and then, of course, your retail pharmacies. We're not going to focus heavily on reverse distributors today, and we're not going to spend too much time on non-registrant disposal, which would be our ultimate users like you and me in our personal lives. But so you know that those are the healthcare sectors that were impacted by these changes. When this first was published, there was a lot of concern expressed by the healthcare community, primarily hospitals, because the way this is written, it appeared to state that any controlled substance needed to be rendered to a non-retrievable state and that was being limited to incineration. And a letter was actually generated by a number of organizations, including American Hospital Association, Federation of American Hospitals, and so forth, to DEA saying, we don't have a way to get a drug from a nursing unit, if it's partially administered, into an incinerator. There's just no way to do it. We can't use reverse distribution. That would be way too awkward. We don't have incinerators available, and we're very concerned that we're not going to be able to comply with this regulation. So that caused a bit of consternation in the market, so to speak, also the requirement to double witness. So DEA responded with a clarification letter on October 17th of 2014. And I'm going to take the time to go through this word by word because this is very important to the rest of our discussion and to our guidance document. So once a controlled substance has been dispensed to a patient by an institutional practitioner on the basis of an order for immediate administration to a patient at the registrant's registered location, the substance is no longer in the practitioner's inventory. For example, after a pre-filled syringe or a single-dose vial or syringe is administered to a patient, any remaining substance in the syringe or vial is not required to be destroyed in accordance with new Part 1317. And that is an absolutely key part of this understanding that came from DEA after the reg was published. So keep in mind now, when it's out of inventory, Part 1317, which is the new drug disposal regulation, is not applicable. Now they go on to say you can't put the wastage in a take-back kiosk, you can't put pharmacy inventory in a take-back kiosk. That was really never a big concern. And the other piece of this is whatever you do with it, it has to be in accordance with federal, state, tribal, and local laws and regulations, including environmental rules and regulations. Then the second part of this reads, although Part 1317 does not apply to pharmaceutical wastage, the DEA strongly encourages all practitioners to continue to adhere to security controls and procedures that ensure pharmaceutical wastage is not diverted. For example, most institutional practitioners have implemented policies that require 2 persons to witness and record destruction of pharmaceutical wastage. So while they're kind of saying it's out of the closed loop, it's no longer part of 1317, we want to make sure you don't let it be diverted. We want to make sure that you're managing this in a manner that is consistent with good practices. So that's really the guidance that we have been working off of to determine the new Practice Green Health Guidance document. So now I want to focus on definitions And while this kind of seems mundane perhaps, we spent quite a bit of time on this because definitions are very important in this regard. They kind of control the next set of procedures, I guess you would say. So obviously we're defining controlled substances as drugs and chemicals that are identified in Title 21 in the Controlled Substances Act. And these are the ones we just talked about, Schedules 1 through 5 in decreasing order of abuse potential. A registrant is a person who's applied to DEA and received from DEA a specific registrant number enabling specific authorization for various functions, including ordering, stocking, dispensing, or administering controlled substances. Inventory, and this is a real key point, are controlled substances that are part of stock, have not been dispensed or administered, and for which tight security controls should be implemented. So that's going to be a key one to keep in mind. Wastage, another key point, a controlled substance which has been removed from inventory in accordance with a physician's order for administration to a patient and which has not been entirely administered to the patient. Now we get into some real interesting definitions. Destruction, according to our understanding of DEA's rule, the standard of destruction established in the DEA rule is to render the controlled substance to a non-retrievable state. This applies to controlled substances within the registrant's inventory. It does not apply to controlled substances wastage. And again, you're going to hear those two terms throughout this discussion. Okay, well, what's non-retrievable? And there's been a lot of discussion about this. Permanent alteration of the controlled substance's physical or chemical condition or state through irreversible means, thereby rendering the controlled substance unavailable and unusable for all practical purposes. So that's been our understanding of non-retrievable. A couple of other definitions we just want to clarify. Reverse distribute, to acquire controlled substances from another registrant or law enforcement for the purpose of return or destruction. And the credit may also be allocated based on the manufacturer's return policy. And a reverse distributor is any person registered by the DEA and appropriate state boards of pharmacy as a reverse distributor and allowed to acquire controlled substances from another registrant or law enforcement for the purpose of return or destruction. So those are our definitions that we're going to use as we move through now what we're calling the cycle of controlled substances. So the first part, you order the drug and you receive it and store it. So in terms of ordering, it has to be in accordance with the DEA requirements. Those of you who are involved in ordering know that Schedule 2 drugs require a 3-part Form 222. I wanted to mention that just recently on February 21st, DEA has issued a notice of proposed rulemaking. They want to change the 3-part order form to a single-sheet order form. You know, that's been around, what, 50 years now? So they decided that that old form, you know, has outlived its usefulness, and you have until April 22nd of 2019 to send in any comments regarding that proposed rulemaking. I really encourage you to take a look at this. You can simply go online, Google DEA Form 222 proposed rule, and you'll have a chance to see all the information on that. That's a big deal. It's been a long time, and it would certainly help simplify matters for those of you that are involved in that process. But as you know, once you receive these drugs in, whether you're getting Schedule 2 drugs on a 222 form or 3 through 5 through just a normal order, once you receive them, you have to verify the receipt. I think some folks have gone to a double receipt format where 2 people are receiving them. Certainly if there's any indication that a drug is missing, that has to be noted immediately. If it cannot be documented between the supplier and the recipient, the registrant, you have to file another Form 106. It gets pretty complicated. So there's a lot even in this initial transfer of drugs into the inventory. But once they've been received into inventory, hopefully you have a system, electronic system, that helps you maintain a perpetual inventory. Many folks are now storing these in highly secured cabinets, sometimes called Pyxis C2 Safe is one brand, for example, but it could be any one of the brands out there that are offering this where you've got your continuous inventory. But even then, I know folks are very often inventorying daily just to make sure in the pharmacy that nothing has gone awry in their inventory. And the automated dispensing machines up in the nursing units are also considered to be part of that pharmacy inventory until that drug is actually removed for administration to the patient. If a drug were to outdate in that automated dispensing cabinet, nursing should send that immediately back to pharmacy for that to be managed appropriately. I know most pharmacies are doing their own checks on those so that they can be sure that they are documenting everything they have on a daily basis so that nothing goes missing. So what happens when we remove something from inventory? Well, the first way that could happen, which is the most common, is the drug has been dispensed to a patient upon the order of an appropriate licensed practitioner. So that would be your normal process of dispensing that for administration. However, the drug might become outdated, for some reason no longer wanted to be stored in the hospital's or the pharmacy's inventory. So now you're faced with this requirement to render it non-retrievable. And based on statements by DEA at various conferences, and unfortunately it's very difficult to get them to put anything in writing, our understanding has been they have publicly stated the only method they accept is by incineration. And we have heard that different regional DEA offices have authorized other methods of rendering a drug non-retrievable, such as chemical digestion. And I'm going to mention a couple times through here, if you are using a different method, please be sure to get that documented by that agent and signed by that agent in writing, because agents move around, and if they've left and you have no documentation, you really have no proof that that was authorized by them. So what would normally happen, or most commonly happen, is that drug, that outdated drug, would be transferred from the initial registrant to a reverse distributor for potential credit, and then the reverse distributor will do the witnessed incineration. And that means literally driving it to the incinerator and witnessing it burned, or accompanying the truck and witnessing it incinerated, and then 2 employees would fill out the Form 41. Now, if you're one of the very rare facilities that is geographically close to an appropriately permitted incinerator, and you do want you have to have 2 employees take it there literally and witness the incineration, complete the Form 41. That's called a registrant record of controlled substances destroyed. You can legally do that. You do need to notify DEA, and they have the right to be there for that process. Personally, I've done this in my past at Capital Returns. It's pretty risky. I mean, it's a pretty uncomfortable position to be in, having these controlled substances in your possession. But, it is legal, but probably not the ideal situation. But it is legal, and we wanted to mention that as an option. So what happens now when we have some unintended consequences? So, for example, if you're compounding morphine IVs ahead of an order, because you don't want people to be in pain up on the floor waiting for their IV, so now you've got some morphine IVs and they've outdated. Our understanding from DEA is those are still in inventory and they would have to go through reverse distribution. And I know we used to take them at Capital Returns. I assume that some reverse distributors are still allowing you to do that. It's a little tougher on the 222 form to fill those out, but it can be done, and that's our understanding of what DEA is requiring. So that would be your option for that type of inventory that would go outdated. And as I mentioned, again, if you're going to get an exception, please get it authorized in writing from your local or regional DEA office so that you can justify if you're doing something different than that. So now let's move to wastage. So the drug has been sent out on an order up to the floor. It's been removed from inventory. It's been dispensed to the patient, but for whatever reason it wasn't entirely used. So it might be a partial morphine IV that got stopped for whatever reason. It could be a partial vial where you didn't need it all, or a partial syringe. And what needs to happen now? In the drug disposal regulation, it does state that such remaining substance must be properly recorded, stored, and destroyed in accordance with DEA regulations and all applicable federal, state, tribal, and local laws and regulations, although the destruction need not be recorded on a DEA Form 41. And what they're really talking about here is 1304.22, which is part of the older DEA reg, where you're required to indicate the name of the drug, the strength, the number of units or volume, the name and address of the patient, and the name or initials of the person administering. So that is still required, even though DEA is basically saying once it's wastage, it's out of the controlled loop. So that whole rendering it non-retrievable does not apply. quite frankly, a number of us were kind of surprised when they came out with this. But that is our understanding of what they're saying, that DEA does not designate or require any specific method for managing wastage other than to prevent diversion and to maintain compliance with federal, state, tribal, or local environmental rules, regulations, or statutes. Now, here's where it gets interesting. We have a few controlled substances that do designate as hazardous waste. Probably the most common you'd see in the hospital and not too often used anymore is chloral hydrate. It's U034, so it's listed waste. Diazepam, 5 milligram per mil injection, is ignitable to keep the Valium or the diazepam in solution until it's diluted. That one you're going to see more often. Fentanyl sublingual spray, probably not so much. Testosterone gel, not so much. But these are 4 relatively common controlled substances that do become a hazardous waste when you decide to dispose of them. So when the wastage kicks in, that's when this EPA rule kicks in. So we want to examine how do these interface together. And before we get into the details of that, we just want to make sure that we're also discussing the concept of diversion prevention. If we're looking at pharmacy inventory, those of you who are reading the journals right now, you'll see there's a lot of different articles on preventing diversion. There's new technology coming out to make it easier to spot discrepancies. Obviously, we want to keep tight controls on receipt and dispensing quantities, restricting access to the smallest number of employees feasible, regular physical audits to ensure accuracy and detect diversion, and then even monitoring on-site reverse distribution personnel, because very often they're writing up your controlled substance returns. So these are just very high level, and I know most of you in that position have much more sophisticated ways of dealing with this. On the nursing unit, up in the OR, where it's really a lot tougher because you've got patient care going on, you've got a lot more variables. Double witnessing at the moment of disposal, which sounds reasonable, but it's not always easy because you have to have 2 nurses available to do that, or 2 healthcare professionals. Following up any discrepancies noted in the electronic wasting records, kind of looking for unusual wasting partners, so to speak, people who are constantly wasting for each other and maybe it doesn't make sense that they are. And then, of course, we want to stress providing convenient sequestration devices. And we're talking here about those devices that either use activated carbon or denaturation to render the drug, and I'm going to call it non-divertible. I'm not calling it non-retrievable. DEA has not said that that's a non-retrievable option. But the point of it is that it makes it very unlikely that anyone is going to get any benefit from that drug, so that the opportunity and the temptation to take that particular container is highly, highly reduced. So we have to mention too, if a hazardous waste like that diazepam is going to be disposed into one of these containers, then the sequestration device itself has to be managed as a hazardous waste and go into the black container. You know, it's not rocket science, but that's where it would have to be disposed. And one of the things we're going to talk about is how easy is it going to be to instruct nursing to segregate, and that's going to be tough. What we really want to emphasize is not to place unsequestered controlled substance wastage in any waste containers, including the red sharps. And I know drugs are being squirted in there, the syringes are going in there, the partial vials are still going in there. They're also going into the pharmaceutical waste containers, both has and non-has. And if anyone in the organization knows that those are being placed in there, that's just a real temptation to either go in and pull them out or to down the road, through that chain of command of storage, transport, and disposal, to have those be diverted. So we really want to encourage you to consider using some type of sequestration device to keep those from being too attractive. And if we talk about drain disposal, because we know that does go on, obviously that's being highly discouraged by anyone in the field who's concerned about the environment, and we're going to show you how this new DEA rule is going to impact that practice. So what we did in the guidance document is set up a decision tree. I'm going to walk through it verbally first, and then we can go through it pictorially. So if the controlled substance is in the pharmacy's inventory, you're either going to be, and you want to get rid of it for whatever reason, outdated for example, you're either going to send it through reverse distribution as a transfer between registrants, or if you have the opportunity to have 2 employees witness the incineration, if a permitted incinerator is conveniently located, then you have to go through that whole Form 41 process. If there's a drug in there that is a controlled substance and a hazardous waste, of course you won't have that incinerator available. I doubt that those kilns would accept someone coming in individually to do this. So it really has to be non-hazardous controlled substances that you'd be looking at there. So that's the first part of our decision tree. If the controlled substance has been charged out to the patient, it's no longer in the pharmacy's inventory, and that means it's no longer in the automated dispensing cabinet either, then any remaining drug is wastage, it's out of the DEA closed loop, and the requirement of DEA is to prevent diversion, and the recommendation is to document and ensure destruction. So those are the two paths we're going down. So then if we just summarize this, if it's in the pharmacy's inventory, it goes to reverse distribution, or you get other disposition from the DEA, be sure to document. If it's been dispensed, then it can be, and hopefully sequestered in a device. That device can be placed in either a white or blue hazardous or non-hazardous waste container, depending on what the particular waste was, and then managed by the appropriate waste vendor. So if we look at our flow chart, we're starting at the top here. We've got the controlled substances coming into the inventory. We've talked a lot about what happens there. Most of them will be dispensed to the patient. If there is wastage left, then we need to dispose of that by any means that does not violate statute or regulation. That is basically what the DEA is saying, and prevents diversion. If we are back in our inventory and now it's expired or unused, we're going to follow that down either one of those paths, and we're either going to send it to a reverse distributor, which will be the majority of the time. They will evaluate it for credit and then either send it on to another reverse distributor, maybe return to manufacturer, probably most likely another reverse distributor. That will eventually end up at an incinerator. For them, it will be an incinerator. However, if you're going to do something with it personally yourselves, you do have the option of coming down this right-hand path and taking it to the incinerator with 2 employees and witnessing the burn, or some other method approved by DEA, hopefully in writing, that has allowed you to dispose of that correctly and render it non-retrievable. So this is our flow chart, which looks simple until you start getting into some of the details, as you can see, which makes it a little bit more complex. So what I'd like to do now is really delve into how the new EPA final rule, Management Standards for Hazardous Waste Pharmaceuticals, and amendment to the PO75 listing for nicotine, certainly a very catchy title, how this is going to impact, in general, our lives, but then also specifically those hazardous waste controlled substances that we've been talking about. So the pre-publication edition was released on December 11th. The final publication in the Federal Register was on February 22nd. It was delayed a little bit due to the government shutdown. It's literally the largest change in the management of hazardous waste pharmaceuticals since the RCRA regulations were finalized in 1980. It's a big deal. Now, some of the big dates. It's going to be applicable federally, in federally managed states and territories, August 21st of this year. So that's Iowa, Alaska, Puerto Rico, and territories. The sewer prohibition, however, of hazardous waste pharmaceuticals is going to be active nationwide August 21st of 2019. And I want to stress this. It is the prohibition of sewering of hazardous waste pharmaceuticals. Only that small 5 to 8% of drugs that become a hazardous waste will be prohibited from going down the drain August 21st from any business. This does not impact consumers, of course, but this will become active August 21st. All the rest of the rule must be adopted by the other states over the next 2 years. And they manage their own program. Some of them have to adopt by July 1st of 2021. Others have till 2022, depending on whether it's by regulation or by legislative action. They must adopt the stricter aspects. They may choose not to adopt the less strict aspects. We have heard of some states that are probably going to go live already on August 21st, but this is something that you'll need to be checking with your state environmental regulatory body to find out when this rule will become active and what parts of it will become active this August. So let's talk a little bit about Subpart P. So why did they come up with a new subpart? Well, EPA has been working on this for a long time, and those of you who've been in this business for a while know that in 2008 they came out with a proposal to put hazardous waste pharmaceuticals into universal waste. And a number of us didn't think that was the best idea because it still didn't deal with some stuff we were worried about. So they pulled it back, and it took another 10 years. But I think they've really spent time on this. I think they've done, the best job that probably can be done in this difficult multi-stakeholder environment, shall we say. And EPA has recognized that healthcare entities are very different from pharmaceutical manufacturing and very different from any type of other hazardous waste type environment. So we've got a lot of healthcare workers who don't have education in this area, trying to make a determination at the point of generation. That's difficult. Our waste stream categorization and accuracy is very challenging. We've got a lot of drugs coming into the market. It's changing constantly. The dosage forms are changing constantly, and that impacts whether it's a hazardous waste or not. Obviously, the number of healthcare workers is voluminous. So lots of good reasons why we deserved some special attention. And they've also noted that hazardous waste pharmaceuticals are different from a lot of other hazardous waste in that they still have some street value and potential for diversion. So they need a little bit more care and concern, shall we say. So what EPA has done in the new rule is they have directed this subpart P to healthcare facilities, very, very broadly defined. If you take a look at the regs, basically includes just about anybody who is carrying or stocking a drug that becomes a hazardous waste, and reverse distributors. And they've defined that very interestingly too. So those are the two big categories that are addressed in subpart P. So let's look at the issues they're tackling. And for many of us, this is a relief because we've been dealing with these issues for all these years now. As many of you know, a number of healthcare facilities are large quantity generators of hazardous waste solely because of their P-listed waste generation being more than 1 kilogram per month. And that can be something as simple as your warfarin packaging, your nicotine packaging, or something going in a retail environment if it got damaged and brought back. So there were a lot of issues around the P-listing requirement being so tight of only 1 kilogram per month. And that's been a thorn in our side for many years. Also, of course, recognizing the RCRA regulations initially, they never thought about health care. So, and then this confusion around the intersection of EPA and DEA regulations, which is unique to health care, because we've talked already about those drugs that are both a controlled substances and a hazardous pharmaceutical waste. And if any of you had to train nurses and tell them that they're going to have to put the empty warfarin blister pack in the black hazardous waste container, and you get the eye roll, and, I can't understand why I'm having to do that, have to suspend logic, we'll be relieved to know that hopefully will be going away. It's going away federally, and hopefully the states will adopt that because it's not even environmentally protective. So these are some things that will be a great relief, I think, for healthcare. Now, what the Office of Resource Conservation and Recovery can control are hazardous waste. So they can control and prohibit now the sewering of hazardous waste pharmaceuticals. But I want to reiterate again, it is only the hazardous waste pharmaceuticals that are prohibited from sewering by this rule. Certainly your state may be prohibiting it, your city may be prohibiting it, and quite frankly, if you are sewering any pharmaceuticals, you are supposed to provide a list of those to your local publicly owned treatment works, sewer folks, and get permission. And I know that that's, not happening in a lot of situations, but legally that's what you should be doing if you're sewering drugs at all. But I just want to be very clear that the hazardous waste pharmaceuticals are the only ones prohibited from being sewering under this new rule. And then there's a lot in the rule about the reverse distribution of outdated hazardous waste pharmaceuticals returned for credit. So that's a whole other discussion because we could do a whole other seminar just on this rule. So let's talk a little bit more now about EPA's response and what subpart P means. This is going to be mandated for all current healthcare facilities that are LQGs and SQGs. That's our large and small quantity generators. So very small quantity generators may participate voluntarily, but they're not required to. And that means you have to go online and register as a healthcare facility under subpart P whenever your state becomes active, shall we say. And by creating this sector-specific standard for healthcare facilities and reverse distributors, this is really a big deal for EPA. It is only the second time in the history of RCRA that this has happened. The first time was in 2008 when EPA created a sector-specific standard for academic labs because the universities were having such a terrible time managing their laboratory waste. So this is a big deal, and we should respect the fact that EPA has really spent a lot of time to do this for us, because it's certainly better than what we've had in the past. It also defines the regulatory status of what they're calling potentially creditable outdated pharmaceuticals. So it does allow legitimate outdates to go back for credit, even though they're going to be defined as a waste at the facility now, not at the reverse distributor. But you won't be allowed to send back stuff that is never going to be credited. If you've repackaged your warfarin, don't send it back under this new rule, because there's more to that story, but the reverse distributor actually has to report you to the regional EPA. So there's a lot more involved here. It obviously addresses this large quantity generator status for P-listed, and then the part that we want to focus on today, it exempts hazardous waste pharmaceuticals that are also a controlled substance from the hazardous waste rule if certain aspects are followed, certain requirements are followed. So we'll talk about that in a minute. It has new definitions of empty in it, which will be important to everybody, and it prohibits that sewering of hazardous waste pharmaceuticals. So you can see there's a whole lot in the new rule, but we're really going to focus now on how this intersects with our controlled substance guidance that we're offering. So I've been mentioning sewering of hazardous waste pharmaceuticals will be prohibited for all healthcare facilities, VSQG, SQG, and LQG. And that is actually going to take effect on August 21st. If you go to the bottom of the slide here, that's being promulgated under what's called the HISWA provision, which is the Hazardous and Solid Waste Amendment of 1984. It's not under the RCRA rule itself. And by doing that, the states do not have to adopt it. It will become effective. It's kind of a mandate across the country. So from then on, those drugs that we talked about that are hazardous waste and a controlled substance cannot go down the drain. So even though DEA allows it for wastage, they don't allow it actually for inventory. If you look at the rule in the preamble, they say that they don't consider sewering to render it non-retrievable for inventory. But now EPA is stepping in and saying, we're not going to let you sewer these drugs for any reason. So that's an important piece of it. And of course, there's a lot of encouragement by other federal agencies to stop flushing. So that's a very important part of this to keep in mind. We've talked about these drugs that are at this intersection, probably primarily the diazepam and the chloral hydrate. So now the EPA will conditionally exempt these from the hazardous waste regulations if they're managed in accordance with the DEA regulations, or if they're incinerated at one of 5 types of permanent combustors, or destroyed by another method that, or I should say and, not or destroyed by another method that's been publicly approved in writing by DEA. And EPA is actually pushing DEA to come out with some type of written guidance on non-retrievable. So I'm hoping that they can have some influence there, because I think that's been kind of a tough part for those of us in healthcare trying to get DEA to commit themselves. But the other incinerators that can be used for the controlled substances that have been a hazardous waste include municipal, regulated medical waste incinerators, and hazardous waste incinerators. So they have to be permitted to manage a pharmaceutical, but now if it is one of those hazardous waste pharmaceuticals, it will be allowed under the new rule to go to one of these incinerators. Now, it's important to note, just because your state has adopted the new rule, if your vendor is sending the drugs out of state to an incinerator in a different state, that state has to have adopted the new rule also. So you can see over the next few years, this is going to be a bit of a rolling target. You're going to have to stay very close to your vendors. They're going to have to stay very close to their particular folks that they're taking it to make sure that everybody is in sync so that a hazardous waste is not inadvertently sent to a municipal waste or a regulated medical waste incinerator in error, and they can't be sewered, whether it's inventory or wastage. So that's a lot to digest, And hopefully you can go back and take a look at this over time. But if we look at the operational impact then of this new EPA rule on controlled substance disposal, while DEA still enables sewering of wastage, if your facility is stocking a controlled substance that becomes a hazardous waste, EPA does prohibit drain disposal of those drugs. It's going to be very difficult, and I would venture to say not possible, to train nurses, put the diazepam injection here into this sequestration device, and you can drain dispose everything else. I just don't see that being possible operationally. So I think from an operational perspective, I would encourage you to consider no longer drain disposing. First of all, it's the right thing to do. But secondly, now you really have a regulatory reason to move away from drain disposal. Use a sequestration device. Once this rule becomes operational, both at your facility in your state and wherever you're sending these, you would not have to pay hazardous waste disposal prices. You could put it into a non-hazardous container, whatever the sequestration device is. So it does give you a little bit more economic incentive to move away from drain disposal. So I think that is something to consider based on what you're stocking in your inventory. Obviously, if you don't stock those, this is a non-event for you, and you can continue to do what you're doing. Obviously, we'd hope that you don't and that you move away from drain disposal. So if we summarize then, the DEA's 2014 final rule differentiates between controlled substances in the pharmacy's inventory versus any wastage remaining after dispensing or administering. Outdated, unused, and unwanted controlled substances in the pharmacy's inventory must be reverse distributed as a transfer between DEA registrants or managed in accordance with regional DEA authorization, including witnessed incineration. DEA requirements for wasting are 2 witnesses, specific documentation, efforts to prevent diversion. Both environmental and security concerns must be considered. Representatives of all relevant stakeholders should be included in your policy and procedure development for each stage, certainly anesthesiology as well as nursing. The new EPA hazardous waste pharmaceuticals rule will most likely operationally preclude drain disposal for facilities that are stocking hazardous waste pharmaceutical controlled substances. So we've got some references here for you that will be available for you to check out. And anyone's certainly welcome to email me or call me if you have any additional questions. And I think at this point, Julie, we'll turn it over to you for any questions in our remaining time.
Perfect. Wonderful. Charlotte, thank you so much. We appreciate you sharing your expertise and your understanding of these rules with us, trying to help us boil it down to understand what we need to do come August 21st, later this summer. So we've had several questions come in. Let me first start with a question. How will we know when hazardous waste controlled substances will or will not be exempt from the state hazardous regulations?
Yeah, that's a great question. And there are some websites, I don't have them posted here, there are some websites who are tracking that. Various companies, some of the waste vendors are tracking that. Some of the returns companies are tracking that. Probably the safest is to literally Google your own state environmental protection agency and just Google, hazardous farm waste rule. And most of them will be posting either whether they're doing it or not doing it. As I mentioned, the 3 states will be immediately, or actually Iowa, Alaska, and Puerto Rico in the territory. But I think watching the Farm Waste Listserv, those of you who are on that, and perhaps that's something Practice Greenhouse might want to consider also being involved in. Yeah, it's going to be a little bit challenging. And the other thing we're trying to determine specifically is exactly what is EPA requiring as stricter. I've actually asked Kristen Fitzgerald to maybe get back to me on that. What do we know they're going to have to adopt, and what are the areas that are a little bit less strict, like the nicotine exemption, that type of thing. So there's not a simple answer. I will mention, though, the HERC site, and I think Practice Greenhouse has had a relationship with HERC in the past. That's the Healthcare Environmental Resources Center. They do try to keep up with these types of things also, and that would be a good site to check with also and see if they're documenting that.
Wonderful. We'll make note of those resources and try to include them in our follow-up email. We had another question come in. This one asks, can hazardous controlled substances continue to be reverse distributed even if they are not eligible for credit?
Yeah, that's a great question. To our understanding, they can, because there's no other way if you're in inventory, and I understand where they're coming from. If it's in inventory, there's really no other way for most folks to follow the DEA regulations. I'm trying to think where that might occur. If it's in inventory, it would normally still be in the manufacturer's packaging. So the morphine is not a hazardous waste because that's in an IV bag, so that can go back. The chloral hydrate would probably be in the original manufacturer's packaging. The Valium would probably be in its original ampule vial. So I don't know when that would happen, but I think you could make a case that this is your only alternative. But that would be a great question if they have a specific drug that they're thinking of and wanted to, send that to one of us. We can take a look at that more closely.
Okay, there's a follow-up that may help with some additional insight. What is a safe way to destroy sepsis for a patient of a long-term care facility that has passed away? And can a long-term care facility use a mail-back packet to an incinerator?
Yeah, that's a great question. Long-term care facilities have a little more flexibility. So assuming you don't have a kiosk, which most of them don't, my understanding is that under the DEA rule, there's a lot more flexibility as to what you can do with that. And I believe a mail-back would be very appropriate for that.
Great. Wonderful. We have another question. Can you please share some examples of the types of sequestration devices that would be needed for the controlled substances?
Yeah, I try not to get into brand names, but there are a number of devices that use activated carbon, and there is a device that uses denaturation. I think if folks would simply Google, I guess you'd say a DEA disposal device, they'll have some alternatives to pick from. It's up to you folks at Practice Green Health if you want to name brand names or not. That's kind of your decision.
Okay. Thank you.
I think it's fine if you're using them as examples, Charlotte. I think it's fine.
Okay.
We're not pushing for any specific product or service. You're just sharing what others are using.
Obviously, Cactus is the one that uses denaturation, and then RX Destroyer or the C2 Returns also uses activated carbon. Those are kind of the three that come to mind as probably being the most common out there.
Okay, great. Thank you. Charlotte, I'd like to pick your brain about some suggestions regarding waste segregation, education, and training for management of, pharmaceutical controlled substance waste. In my practice, very often we have a syringe of remifentanil left over, and we have been just like kind of ejecting that into the trash where it's absorbed by the materials. I understand that come, August 21st, we just need to look at doing that differently, period. But it's more like diazepam and the hydrochlorate come August 21st that we're going to have to make sure gets put into one of these sequestration devices that eventually goes to incineration. Do I have that right? And then secondly, I'd love to get your input on what are some of the good education methodologies or techniques for getting this out to the end users.
Yeah, I think the first decision the organization has to make is what are they going to use for sequestration. Let's just assume you're going to do something about that. And I think that's where you want to look at the different devices, look at the costs, and then absolutely bring in nursing, anesthesiology, anyone who's going to be involved in disposing of the wastage up in the nursing unit or up in different parts of the hospital, make sure that they're involved in the decision. Because one of the things we hear, the most important thing is to make it handy, that they don't have to walk, miles to get to this device. So you want to be looking at placement of it, ease of use, security of it, so that people can't walk off with the device, because that, even though it's sequestered, some people don't understand what that means, and they think they can get some drug out of there. So the first thing is to look at the different units, try them out, do a trial, and then the ideal situation would be to, once you've brought them into the organization, is have your training on how to use them. And, we don't like drugs going in the trash anyway because, for lots of reasons. But the whole point of it is to tighten up how these drugs are disposed of, to make sure that they are managed in a way that they can't be diverted, because a lot of diversion does occur, unfortunately, in healthcare. And then once you've established that, policies and procedures need to be developed, and then a training program needs to be developed. And very often now people are using their e-learning systems, or they're doing nursing station to nursing station. That's tough because you've got 3 shifts or 2 long shifts, whatever. It's not a simple process, but I think those organizations that have gone to this type of procedure, the nurses are very happy with it. They feel really good about the fact that they know that these drugs are being secured, they're not going to be diverted, and they're being environmentally managed in a responsible manner. So it's like any other change within an organization, getting consensus, getting buy-in, making a good economic and environmental decision for the organization, and then making sure that that gets communicated effectively to all of the relevant stakeholders that are going to need to work with that.
Great suggestions, Charlotte. Thank you. Especially that e-learning. We're doing that annually, so that's a great opportunity to kind of reinforce this education with our healthcare providers. So that brings us to the close of our call. Once again, we would like to thank Charlotte for sharing her expertise and her understanding with us. And we would encourage you to join us in Nashville, May 7 through 9 for Clean Med for additional discussion and around advanced guidance on how healthcare facilities can properly manage controlled substances, as well as some further insights into the DEA and EPA regulatory landscape as it pertains to healthcare pharmaceuticals.